Stuart Schmidt's out
Yeah.
skiing out in Colorado. What are you doing?
What are you doing?
You're muted.
You're muted.
Okay. Um,
Get my exercise in. It's cold out here.
Wow.
yeah, well, that's what happens when you're in Colorado. It looks like you're, what are you, where are you?
I'm in sunny Crofton.
Okay. All right. Can we go? Are we live?
Yes,
Yeah.
we are live.
Okay. This is the subcommittee, the Civil Law and Procedure Subcommittee, the Judiciary Committee. It is 3:10 at 10 o'clock in the morning. We have three bills that we're taking up today. Thank you for all the committee members that came on. And if you're not on screen, then you'll just raise your hand or say aye if you want to be heard, or nay if you want to be heard. The first bill we're going to take up is House Bill 74. We talked about this a number of weeks ago. Before we took up the Embry bill, we took up this bill. This has to deal with publications and how and whether publications should be digital versus in print. We do have, I believe, Rebecca Snyder in the waiting room if she wants to come on. There's an amendment that was proposed that Delegate Foley was okay with. Delegate Foley, just FYI for everybody who knows, this is not cross-filed, so this does need to get over well before crossovers, which is why we're trying to take this up now. Holly, do you want to explain? The amendment is a very simple amendment. It changes an or to an and. After further consideration and discussions both with Ms. Snyder and Lorenzo, as well as with staff, it appears as if this does not create a windfall for any particular publications, that the publications that if you do get a rate from the publication, it would be blended, and this wouldn't change anything as to in terms of the pricing. That being said, there is the outlet of the second part of the bill, which says that if there is no written publication, I don't know if that's the right way to describe it, there's no actual print publication, that the digital publication will suffice. Holly, do you want to describe if there's any technical issue with the amendment that?
So all it is if you look on page 2, line 16 and line 18, that or becomes an and that's the only thing. And I don't know if Ms. Snyder wants to chime in here, but from my understanding, you have it correct. It just then allows them to do either print and digital.
Print and digital.
Correct. Yeah. It is. So the idea of the bill was that you could start the clock running in the digital version, and so that's what it does. And I am stopped, even though you can see my car.
Okay, fair enough. That's okay. All right. So I'd like to ask for a motion on the amendment.
Move favorable.
Okay,
Second.
great. I'm trying to get David Moon on. Yes, we have begun.
David's here.
David's here.
Okay. Okay, good.
Mr. Chairman, I have my hand raised.
Yes, Delegate Conaway, and then Delegate
Yes.
Brown.
So how is the decision made for the and?
If there is a and Ms. Snyder will correct me if I'm wrong, if there is a publication that is both online and in print, then they will allow the online publication to happen immediately so that they can get started right away. If they only have print, it will only be in print. If they only have digital, there is the exception that allows them to use just the digital if they don't have another option. So that is that. So, but if it's both, they are allowed to do it in both the print and the digital. And that's what the amendment is intended to do, to make sure that it doesn't specify that they're not narrowed to only one or the other. Is that correct,
So-
Ms. Snyder?
Yes, that's correct.
Okay.
So a place that just has print, they'll be able to print, plus the registered wills office will print also? Is that what
This
we're
is
saying?
only, excuse me, it's only for government notices, so it doesn't have anything to do with the Register of Wills.
Right.
And if they only have a print publication and no digital, which there's no member that carries notice now that does not have a digital extension of their print publication, they would be able to just serve in print.
Okay, all right, thank you.
Right. So, if again, this is not it. This is not the Embry bill that deals with the estates. This is for all. This is for a general publications bill. Okay. Delegate Grammer.
Thank you, Mr. Chair. Can you just refresh us as to the impetus of the bill? Like, what is the bill trying to accomplish?
Is trying to make sure that people who want to be able to utilize digital publications can be able to do it. Delegate Foley, similar to Embry, but not with the same fiscal implications for publications, is trying to facilitate an ability for folks to get publications out a little bit more expeditiously. And it doesn't have to do with registers of wills. It has to do with just being able to get digital publication out more easily.
And if
That
I
fair to
understand it,
say?
John, and if I understand it, John, if I could, if you don't mind.
Yep, sure.
It also allows for those markets that have gotten away from print news to be able to distribute it through their electronic news or digital news formats.
Which
Did I say that right?
Right. That's correct. And it's the intent. I think that and Delegate Foley's not on, but I believe her intent is to help the people who want to get their things published as quickly as possible. But yes, I think that one of the offshoots of it is that it allows for the folks who are using digital venues to be able to participate in this kind of publication. Is that what you're saying, Delegate Phillips?
That is.
Yeah.
And I think I saw Rebecca shaking her head.
Yep. Okay.
just
Delegate Schmidt.
Thank you, Chair. Delegate Congolo is in the waiting room.
Okay.
If somebody could let her in.
Thanks.
You're welcome.
We're working on it right now, I hope.
All right.
And Ms. Snyder, did you have anything else you wanted to add? I apologize. I cut you off.
Oh, I was just going to say that really it's about weekly publications. So I think many of us are spoiled with a daily print publication, but the impetus of the bill was actually the Dorchester County Commissioners who couldn't get their notices in on time because their papers of record, of which they have 2, were all weekly. And so by putting it into the digital version of that print publication, they can start the clock running much more quickly. Delegate Foley thought that would be a good thing to extend statewide and also provide a runway for if there would cease to be a print publication in any jurisdiction. That's not the case now, but it provides a runway to digital only notice if there are no print publications.
And you guys in the Publication Association are okay with this, right?
100%. We worked very closely with Delegate Foley and last year with Delegate Hutchinson on this bill.
Okay. Holly, any word on whether Delegate Congolo is available?
I think whoever T is, can you just check? Do you want to call out?
That's me, Latoya Congola. I'm just going to change my name now.
Okay,
Okay,
perfect.
that'd be great. Thank
Right.
you.
Thank you. Okay, now, all those the amendment is on with a second. All those in favor of the amendment indicate by either raising your hand or yelling aye. Okay.
Aye.
Anybody opposed? Those of you off screen, if you're opposed, you got to let me know now. Great. So now the amendment, the bill as amended. Is there a
Move
motion?
favorable.
Second.
Okay, great. All those in favor of the amended bill signify by raising your hand. Is there anybody opposed? Great. Except for David Moon, I think is not opposed. I think he was just late on his.
Correct.
All right, we're done with
Mr. Chair.
House Bill 74. House Bill 660.
Mr. Chair,
Yes.
is it appropriate time to add or what's the story?
Oh, you wanna ask for an ad on that?
Do that in
Yeah.
committee.
We'll do that in
Committee.
committee. Thank you.
Oh,
We
okay.
take a full vote.
Okay.
Oh, okay, thank you.
Okay. House Bill 660. We discussed it in last week, a few weeks ago. This is a bill that would, by all intents and purposes, allow the bypass of the Register of Wills and the court system and bypass the orphans court and the court system and let the Register of Wills basically begin the process of administering a will without the approval of the courts. I think that's what the intent of the bill. There was, as we indicated, and I think that Byron McFarland was on last time, there was, he was refuting testimony from the judiciary and from the orphans court, both of which said that they had significant problems with this. This was bypassing the proper judicial oversight. I'm not persuaded by Mr. McFarland on this. I called up the legislative folks from the judiciary, specifically Judge Stacey Mayer, who indicated that yes, they believe that this is in fact inappropriately bypassing judicial oversight. And then I got calls from a number of orphans court judges who refuted the comments of there being backlogs and it taking a long time. It was specifically Baltimore County, where it was indicated that there was a big backlog, that is just not the case in terms of what this would solve. So that's my opinion. I am not persuaded. I am happy to continue to hold the bill, but I do not believe that. I personally don't believe the bill is ready for prime time since there is not any kind of peace in the valley on this. Delegate Conaway, did you have a comment?
I did, but I'm gonna go with the motion to hold the bill.
Okay. Is there any other, Holly, is there any other information that I am not privy to on this?
No, that's about right, where everything stands right now.
I'm
We
also
did invite
happy.
some judges,
Yeah.
but they weren't able to come from the orphans court, but you spoke to them, so.
I spoke to Miss Fisher and I spoke to there was another orphans court judge that called me. I can't remember. It was not from Baltimore County. I can't remember.
So I got just so you know, I got a note from Melissa Hollett Bright, Maryland Association of the Judges of the Orphans Court, the president, and
Okay.
also from Judge Greer. My challenge is I'd like to hear from them, and it would be good if we heard from them directly, because I still don't understand all of their concerns, Mr. Chair.
Okay. Then I'm going to suggest, because I'm also would have taken a unfavorable on this, but I'm going to hold. I think we'll hold it, and we'll see if we can. Delegate Williams, did you have a comment before we hold the bill?
Yeah, no, I was just going to say I heard similar comments from one of the orphans court judges in my county. Judge Groves had mentioned She was at another event that I was at a few days ago, and she had mentioned to me in passing some concerns that they have with this bill.
All right, I will ask them to come and either speak to us or
And Chair, I'll just chime in here. We do have one more civil already lined up for this coming Wednesday. So I will reach out if they're listening, try to get some of the orphans court judges to join us that Wednesday meeting, hopefully.
okay, great.
That would be great. Thank you.
Thank you.
Um,
Yes, Delegate Tolles.
Thank you, Chair. Claire, the same. Could you let us know ahead of time? Nicole Williams and I were at the same meeting with the same orphans court judge. Can you let us know ahead of time so I can see if she can be a part of the meeting?
Yeah.
When it's scheduled, we can let her know.
Right now, we're scheduled for, I think, a Wednesday right after.
I think it's at 5 o'clock it's either 4 or 5 o'clock on Wednesday.
Okay.
Okay, great. Thank you both.
So we will,
Thank you.
and I will, we will try and reach out to the association, see who they want to send. That's great. All right. The last bill on our agenda is House Bill 1420. Is that correct? Let me pull it up. Holly, is that the
Yes,
number?
that's correct.
Okay. We also spent a little bit of time on this.
No, this is a brand new one.
We didn't spend, oh, then I spent time on this, I guess. This bill requires each Register of Wills in consultation with the Register of Wills Association to offer a method by which an individual without government-issued identification may prove the individual's identity as the heir or the beneficiary of the will. Yes. Okay. Holly, can you tell us the impetus on this?
So from what I understood, this had to do with, in particular, the key, the key bridge, and there was a young lady who testified that was unable to open the estate because she did not have proper identification. So this is providing an alternate route if you don't have a government issued ID to open an estate.
Right.
There was no unfavorable. There was one favorable with amendments, but I think it was just more technically based. So.
I do remember. Yes. Now that so we have not talked about this in subcommittee, but I have spoken with the sponsor about this. Each Register of Will, in consultation with the association, will have to figure out sort of the method of proving an individual's identity. So it leaves a lot up to, I guess, the professionals to just certify. It doesn't specify in law what type of documents or anything like to that. Is that correct?
Yes, it's just they have to the registers in consultation with the Maryland Registers of Wills Association are going to have to create an alternative method so that an individual's identity as an heir or beneficiary can be proven for estate purposes.
Delegate Embry.
Oh, thank you. I am supportive. I had my notes because there was the Maryland Volunteer Legal Services had a requested amendment to delete a requirement of citizenship in a separate part of the code. I just didn't know if the sponsor or you had considered that. And then the second is just the Register of Wills had they did have some kind of technical amendment, but I don't see it. And I wondered if that was also proposed or considered by the sponsor.
I haven't seen any
Okay.
amendments. I just talked to him, but he was it was the emotional side of it more than the technical side. So I don't have any of that. I will, Holly, we can figure out if there's amendments that we need to.
I don't have any on hand. The one that was in the testimony requiring citizenship was another part of the code. I think that from I don't know if that necessarily would fall under this particular bill, but that's a policy decision the subcommittee has to kind of take up. And then the technical amendment, I never received anything like from the registers on that. So I'm not sure if after the bill hearing they determined it wasn't necessary. I'm not sure.
Delegate Grammer.
Thank you, Mr. Chair. Just a couple brief comments here so everybody's aware. I'm okay with the premise of the bill, but I think everybody should understand there's an immigration issue here. The second, I guess, point or question I wanted to bring up is how technically, I mean, are we okay with writing a law that just kind of defers to each jurisdiction to make up some kind of process? I just hear everybody as we're talking through the bill. It feels a little weird to write a law that says, well, just kind of do whatever you want. It just seems, again, I'm okay with the premise, but it seems like maybe we should specify that a little bit, or clarify what the options are. And I just feel very weird passing this bill, having no clue what those options are going to be by the local jurisdictions.
Delegate Phillips.
So the bill really doesn't do that. What the bill says is that the Register of Wills at the state level, their association, has to come up with how they will go about determining a person's identity. And so they have to come up with something collectively. We're not going to have 24 different methodologies.
I don't know.
So on that one, I'm okay.
Is that actually what the bill says? Let's just,
the bill says, yep, hold on a second.
Each register, in consultation with the association, shall offer a method by which the individual without government-issued ID may prove.
Then maybe I'm wrong, and that's. Let me see.
I mean, it's a good thought, Delegate Phillips. I'm just not sure that that's what it does.
Then maybe that's what we need to change, because I agree with Grammer.
Yes, Grammer,
Yeah,
did you have something else?
Yeah, that's the way I read it, was that each jurisdiction could come up with a rule. And it's just just think through it. Like, if you end up even having all the registers come up with a plan, that's still a little wonky. And if we end up having each, it's just very weird to me.
So here, a couple of thoughts, and this goes back to Delegate Embry's comments. First of all, I don't think that citizenship should matter. I mean, this is just my own personal opinion, because we're not talking about whether and legal status shouldn't matter. We're just talking about being able to administer an estate so that the property can be properly designated to the right individuals, regardless of where they are. They could be in a different country, but we still need to be able to make sure that we have the right person or people making those decisions and overseeing it. So this isn't about legal status. This isn't about whether you have to be. They don't even have to be in the United States. If they're deported, it shouldn't make a difference in terms of being able to administer the estate.
No,
Except,
but they
I guess,
do have to have. You do have to remember they do have to have a local point of contact. So you can be an executor or a personal representative, but you have to have someone else. And I think I listened to that hearing pretty carefully. So I think that was one of the issues as well.
Mm-hmm. Okay. Any other comments and thoughts? I mean, it sounds to me like we are not, this is not impacting the people who testified, right? They worked out their situation. Is that correct?
Did they?
I don't know.
Were they in Baltimore County?
I think so.
Yeah.
Yes.
So I think we need to know whether this is to help deal with that particular estate, or whether that estate has already they've already figured out a way to do around, circumvent and figure it out. Yes, Delegate Williams.
Yeah, so Mr. Chair, what I think, well, I mean, it would be nice to know the status of that estate and where they are in the process and if they were trying to get it resolved. But I think more importantly, I think the impetus behind this bill has nothing to do with the very unfortunate situation at hand, but more these things happen from time to time where you just can't find the actual original will. And I think that's what this problem I thought was seeking to solve. The one question I had, I'm just trying to piggyback off of what Delegate Phillips mentioned about someone being in Maryland. The bill doesn't specify that. And I guess maybe this is a question for council. If there's some other section in the estates article that does specify that the administrator or the personal representative has to be in Maryland or someone to that effect.
So if I couldn't go, I'm not saying the PR has to be in Maryland.
Okay.
If the PR is not in Maryland, they have to have a local point of contact, and I forget, I mean, almost like a resident agent.
And that's already in the code.
That's in the code.
Oh, okay. All right. Well, that part that is helpful. I don't think we need to clarify that in the bill, but I do understand the concern about clarity about what the process will be, what the process will, the process by the register of wills when they're presented with this situation. I think the reason the orphans courts don't like it is because it takes the jurisdiction out of their hands in terms of verification of the document that's being presented, and putting it in the hands of the register of wills. So.
Right. So we do have information. I just got an email about some information about an amendment that is attempted or was attempted to be drafted and presented. And then a question as to whether that amendment would work or not work. It's a sponsor amendment. I'm going to make the executive decision to hold the bill until Wednesday, get some more information. But in the interim, I want to finish this conversation first. We have a couple minutes, then we can give everybody time until criminal starts at 11, excuse me. So we want to make sure, number one, that we're not setting up, this is what I'm hearing from you guys. I don't want to set up a situation where we allow for additional litigation because you have people coming in attesting to be the correct representative, but then we have other information that refutes that. And that would be what I would say, that would be my biggest concern is that, in the Key Bridge case, I don't think that's an issue, but what if there's a brother who everybody knew had the will, and then the wife comes in and says no? I think that if there's no will, it's pretty clear how the property is distributed. But if there is an allegation, if there is a will, I'm just kind of putting out there that I don't want to create, and if none of them can be properly identified because they don't have proper identification, does that open up a can of worms? Yes, Delegate Embry.
I'm just a little confused. I see this bill as only allowing identification, verification. That's all I'm reading in this bill. So I think it could help avoid, potentially, I don't know, potentially even avoid litigation because you're not forced to disregard a person who has an interest, an heir, because they don't have a government issued ID. But you guys do this work professionally, so I defer to.
Based on that, Delegate Phillips, is that so? If all it does is helps you identify the person,
that's it.
Because
that's how I see it.
Because you can't, because if the person can't properly be identified, then we can't ascertain that it's the wife. Is that the issue? Correct. So that the wife, if it's intestate, the wife would then be the primary beneficiary.
That is correct.
But if she can't be identified as the wife because she doesn't have ID, that's the issue? Is that what we're talking about here?
That is correct.
That's it.
Okay.
So not only, there's a series of things. If I can't be identified, then I can't be confirmed as a beneficiary. I can't serve as the personal representative. I don't necessarily not required to give me notice. So that ID is extremely important.
Mhm. Okay, so this is really just about notice. This is not about claiming any kind of rights
No, it is.
as an interested party.
It is about claiming rights as an interested party, but I have to be able to be identified before I can be considered for any of that.
Uh-huh. Okay. All right. Well, we're gonna hold
To
it.
me, the biggest issue is, I think, the one that Delegate Grammer raised, and I agree with him 100%. The language in here about the method for identification, whatever we do on this one, it should be consistent.
It should be consistent across the state. Absolutely.
Okay.
I would think to agree with you on that as well. Okay, Delegate Williams, last one, and then
I'm sorry to beat this dead horse.
that's right.
I guess this is a question for council. Are there any other sections in the code where that kind of deals with this issue about an attempt to verify if the individual doesn't have a government issued ID, or is that something I guess you would need to get back to us on?
I think I'd have to get back to you. And I think at this point too, I would want the registers to come in. Maybe Mr. McFarland, for example, could walk us through that a little bit more to see exactly where this carve out is. And I do believe that amendment that the sponsor has, Mr. McFarland emailed me, it changes the bill drastically. So that's something we'll have to look at as well.
Okay. All right.
Okay.
And I don't know if citizenship should be a requirement, as was stated earlier, but that's all I had, Mr. Chair.
Great. Okay. Well, this was a pretty good meeting, and I appreciate everybody's perspectives. And at this point, I think we are done until Wednesday. We're going to get back. We'll revisit this bill. We'll revisit 660. I have already gotten some texts from people listening in on this, so hopefully we'll have some more information by then. And I think we got a letter from I'm just going to tell you, I just got a letter from the Maryland Association of Judges of the Orphans Court opposing the legislation with explanation as to why. I think we already got that information, but I just got it re-texted to me from one of our Orphans Court judges in Baltimore County, Judge Fisher. So,
Got it.
okay. Any last things? I'm not used to us not having to rush. So those of you on criminal starts in 20 minutes, and I'm assuming Delegate Moon's already out there getting ready for it.
And for all those listening, I will find out exactly on Wednesday when our meeting is. So that will be posted. I'll have Hunter post it later today on the website. So if that way we can let the judges know, or if anyone's coming on for this one too, but it's either 4 or 5 o'clock on Wednesday.
All right.
Great. Thank you all very much. This is the end of the